This video is for reading 7, which is entitled Culling the Masses: The Democratic Origins of Racist Immigration Policy in the Americas. And it was written by David Scott Fitzgerald and David Cook Martin. And it's an excerpt from their book. So the reading begins by pointing out what they say is paradoxical information about the United States. Um, they point out the fact that the United States is the world's oldest continuous democracy. And we've kind of positioned ourselves as a country as being like a beacon, an illustration of what a true liberal democracy looks like. And we have both implicitly and explicitly kind of held ourselves up as kind of a paragon of liberal democracy that other countries should emulate. But as the reading notes, we were also the first independent country in the Americas to introduce racial selection in the process of naturalization and immigration. So, naturalization, of course, being the process through which a person becomes a citizen. And we were late, not the last, but we were certainly late to end racial discrimination in the processes and policies of naturalization and immigration. The authors are labeling this a paradox because we are a liberal democracy, yet we cull our newcomers by race, meaning we select some and we don't select others. And we do this all while proclaiming that all men are created equal. And so they say this is just a deep contradiction in US history. And so this is a historical reading. I don't have a lot of sociological context or background to add here. This isn't necessarily based upon primary research or data collection like a lot of our more sociological pieces. This is a history based chapter. So a lot of acts, a lot of policies, a lot of court cases. I'm going to highlight some, but in a lot of cases, because I don't have a lot of additional to add, it is about reading the excerpt closely. So there is a really great table on page 80 that kind of lifts up some of the principal laws in the US that have been related to immigration and nationality selection due to race or ethnicity. The very first one, the 1790 Act, which restricted naturalization, was restricted to free whites. They give you some backstory about how America came to this policy, as we kind of made our way from being a colony of Britain to establishing our own our Declaration of Independence and establishing our own country. And so the 1790 Uniform Rule of Naturalization restricted eligibility to naturalize to free whites. And they say, this seems so obvious to lawmakers that, they didn't really even debate over the whiteness requirement. What's interesting, I think, to me here is the fact that, the book notes that even though this seems perhaps like very racist and limiting, at the time it was pretty progressive or revolutionary, because it allowed for full citizenship for Jews, a religious ethnic group that wasn't necessarily recognized as being white and not necessarily eligible for citizenship in countries such as France. It also, of course, recognized Catholics as being white. And I know that might sound a little silly today to think that somehow people thought that on the basis of religion, especially for a group like the Catholics, that they were seen as being something other than white, but that certainly was true. And your book notes, for instance, the UK at that time, didn't allow Catholics to necessarily have full citizenship. So they opened the eligibility to become citizens to all of these white categories, and largely this was for demographic and military expansion reasons. They wanted to have as many people as possible who could be considered citizens, who could be called upon to fight in the army, because that's a really important thing to consider when you are a new fledgling country that is populated by rival powers as well as indigenous groups. So if you're going to say that free naturalization is restricted to whites, then of course it brings up the question: how do we define who is white? And so they kind of go through, a bunch of court cases where they were trying to establish, who is white and who is not, because that is the basis of naturalization. And so on page 81, they say that that there were 52 court cases between 1878 and 1952, and the focus was usually not so much on defining who was white as the focus was on defining who was not white. But oftentimes, a lot of these cases, could be contradictory. They had contradictory rulings, and so they go through some ways in which we had some contradictory rulings in these early cases in regards to such groups as Syrians, Armenians, Filipinos, Japanese, and other and Asian Indians. Um, and sometimes it wasn't just even the individual judges and their interpretation, but even foreign diplomacy and international agreements would come into play. So they specifically talked about, for Mexicans, the definition of who was legally white became intertwined with, U.S. treaties with Mexico. Um, so they said that even though they were typically racialized, that at least at one period of time, due to kind of foreign relations concerns, they were treated white by law. So all of this just kind of reflects back on the fact that we oftentimes think of race as being this matter of fact, straightforward thing, but in a lot of ways, it's very socially constructed. And one way you can kind of see the ways in which it's socially constructed is if you look at our history of court cases and our history of government policies around the topic of race. So then the reading moves into some treatment of specific groups. So for blacks, they weren't just restricted on naturalization, but in at some periods in our nation's history, they have banned migration from other states. And they have banned the immigration of people considered black from other countries. So, not allowing free blacks, for instance, from the country of Haiti, where there had been a slave revolt in 1791 and they established a black republic. They did not allow them they banned immigration from that country. The Dred Scott Sanford decision in 1857 pretty much said that blacks, even free blacks, were not considered citizens, and so therefore any of the rights and liberties that the Constitution, set aside for citizens, African Americans, blacks could not call upon these rights. That was the Dred Scott decision, and that was really significant because that meant even if you weren't living in a slave state, even if you were free black in a non-slave state, you still were not, you were living in a country that didn't recognize your citizenship rights. And it's worth noting that that Supreme Court case largely stood until the 1868 14th Amendment that happened, after after the Civil War, as well as the 1866 Civil Rights Act, which basically, extended naturalization citizenship rights to blacks living in the country, but it still did not encourage black immigration, right? So it's kind of like, hey, you're already here, we're going to acknowledge you as citizens. And keep in mind, in some cases, you've been here for your family has been here for hundreds of years. So we're finally going to acknowledge your citizenship. But this did not end the restrictions on black immigration from other countries like Haiti and other countries in the Caribbean. So if you immigrated, you still were kind of left in this this gray zone when it comes to naturalization. Then your book talks about the treatments of Asians, in particular Chinese and Japanese. So the Chinese were the first target of a first federal restriction on immigration of a particular racial group, meaning there was a policy that, like, name checked them, named them by name, like that we are not going to allow people from this country into the United States. And so that was the Chinese Exclusion Act. And in order to understand the Chinese Exclusion Act, you need to kind of understand, the state that led it. It was led primarily by the state of California, because at that time, that's where we had, our larger Chinese population, and they were primarily there, working as cheap labor, particularly for the railroads. They were paid lower wages than white railroad workers. So they were sometimes used as strike breakers. So that did not increase their popularity in the eyes of the white population. They also kind of formed their own ethnic enclaves and niches, which further kind of raised suspicions and increased hostility towards them. So when California had passed a statewide referendum about whether or not Chinese immigration should be allowed, it was overwhelmingly opposed, meaning people opposed additional immigration from China. And so when the Chinese Exclusion Act was passed, on a national level, it largely was due to this push by the state of California. And so, if you've ever visited like San Francisco and Chinatowns, it was because once this happened, and you now had ethnic group that was here that was unwanted by the majority group. It was due to basically enforced residential segregation, and in some cases occupational segregation. So they formed these enclaves as a way of protection, and not because they were refusing to assimilate, but because at this time their assimilation in larger society was not desirable and was not wanted. The Japanese kind of have a similar history in the U.S. In the extent that they also were kind of excluded in a lot of ways from being allowed to fully integrate because they were seen as racialized others. Um, and then they were then blamed for not assimilating, even though they, as your book notes, they weren't welcome. And part of what allowed them to kind of not face the actual ban that the Chinese faced, is because of a bit of policy that is known as the 1908 Gentleman's Agreement, um, which basically was the president of the United States, and the emperor of Japan, um, saying, and it's called a gentleman's agreement because it wasn't a formal treaty, but basically what they said was like, look, if you limit immigration with the E, so leaving your country, if you limit immigration on Japan's side, right, basically make it hard for people to leave Japan to come to the United States, like don't permit it, don't provide that type of permission, then in exchange for that, we won't go so far as to ban in actual policy, the immigration of of Japanese, because it was obviously seen as very insulting, to have this racialized ban placed on the people of your country. So in this way, even though they didn't experience that targeted ban, it was more or less still a ban, a restriction on their ability to immigrate to the country. And then the Immigration of Act of 1917 then just banned labor immigration from all of Asia in general. So if you want to take a look at some of the additional sociological background slides, a lot of this is just kind of talking about the precursors of the Chinese Exclusion Act of 1882 and the consequences. One major consequence was it delayed the second generation of Chinese Americans, because what you had were a lot of male Chinese laborers that had moved to the United States to work. And then they were going to send for their families at a later date. And they kind of got caught up in the Chinese Exclusion Act. And so we basically created a generation of bachelors, and this was furthered by the fact that a lot of states, California, for instance, had um, uh, what they call anti-miscegenation laws, where they wouldn't allow racial minorities to legally marry people outside of their race. And although a lot of states, these laws were targeted towards Blacks, African Americans, it's worth noting that there were some states, California being one of them, where Asians were also targeted, where these anti-miscegenation laws did not allow them to marry outside of their race. Now, for the Japanese, like I said, because they did not have that official ban, that 1908 Gentleman's Agreement, part of what it did allow for is, even though it did not necessarily allow Japan to keep sending male laborers, it did allow for things like them being able to bring their children and wives over in limited numbers, and so they didn't experience that same delayed second generation as the Chinese did. And part of why this is really significant is because then, if you skip ahead 50, 60 years to World War II, and Japan has bombed Pearl Harbor, the decision by FDR to place people of Japanese ancestry in internment camps has greater significance when you consider the fact that of the 120,000 Japanese Americans detained in the camps, about 80,000 were US citizens, 40,000 were younger than 19 years of age. And so, and by emphasizing that these are US citizens, it's not because they had gone through a naturalization process as immigrants. It's because, by and large, these were young people who had been born here. And, there's a lot of great information and documentaries on this Japanese internment um, decision, and what life was like at these camps. They were given 2 to 5 days notice to dispose of their homes and property. And oftentimes there would be, you can see a photo of it, there would be these public notices that would be posted around town. And if they refused to leave, then of course the military and the police got involved and they were seized. A lot of Japanese property was lost. The estimate is 400 million during the time that they were in, these camps. Um, they are one of the only ethnic minority groups, racial ethnic minority groups, to receive not just an apology but reparations. Although by this point, at 40 years later, obviously a lot of the people who experienced internment directly had already passed away. So that is kind of the discussion around the treatment of Blacks and the treatment of Asians. And so the final group that they kind of address is, well, then what about, of course, early on in the history, it was like, we we welcome all free whites. But, did that remain the case? So the question here is, were all the European ethnics wanted? And the subheading in your book is filtering the scum from the melting pot. So it's worth noting that, up to World War One, most European immigrants were not excluded. It was, between 1880 and World War One. No one was really excluded, and specifically, they weren't excluded on the basis of ethnicity. The book talks about like bans on things like criminals or people that they labeled lunatics or idiots, and those likely to become a public charge, meaning that they would come to America and not be able to be productive, workers and citizens. It really wasn't until after World War One where we really started to see a growth of some specific uh, anti-Irish, anti-Catholic, anti-Southern European sentiment. And your book talks about the role of what we call scientific racism in all of this, and it's this idea that, as opposed to thinking that all Europeans are whites and they share the same heritage, instead they started to kind of separate them into different European races with distinctive phenotypes and inherited social and behavioral characteristics. With some of those social and behavioral characteristics, things like drunkenness or laziness, promiscuity, being qualities that some people in America said, was not desirable. And so, before they actually began establishing national quota laws, and this is 1921 to 1924, where they actually assigned specific quotas of the number of immigrants they would accept yearly from countries where obviously desirable countries had a large quota, non-desirable countries had either a low quota, or if they were like in South America, Africa, Asia, by that time, they just weren't accepting them, any immigrants from those countries at all. But before we even did that, they tried to use literacy tests to try to keep out European ethnic groups that were seen as undesirable. And these types of tests also, of course, then also kept out people that were not necessarily um European as well. And your book talks about that. Is that, even though on the books there were exemptions for the Western Hemisphere, the countries that are like right here around America, there were specific practices that they would engage in, as a way of trying to restrict Latin Americans and Caribbean blacks. But because those countries were so close to us, a lot of these were de facto practices as opposed to de jure policies on the books. Because once again, for diplomatic readings. So this reading ends by asking us to consider in what ways contemporary immigration policy, while not necessarily overtly discriminatory, might still lead to unfair, unbalanced admissions that privilege some groups over others. And so, and what does that mean for kind of our status in the world as being this beacon of democracy? If we are still racially excluding people or making it harder for certain people to enter or become citizens, once again, how does that play into that paradoxical image that the US has? And so that's really the questions that I encourage you to consider. What do you make of that paradox that lies at the heart of America's origins slash early history? Currently, there's a lot of debate about how this early history should be presented and taught. What side of the debate would you fall on, and why? How knowledgeable were you before completing this reading about a lot of these early policies related to citizenships that existed in this country, which led to some people being restricted and cut off from citizenship? I think this is an important question to ask because sometimes when people are arguing against assistance that we provide to other countries or to immigrants, they say things like, "I'm a citizen here and my family's been here for generations." Hopefully, maybe this reading makes you consider how having the type of family that was able to be here for generations and be recognized as citizens for generations is a privilege in and of itself. It doesn't just reflect agency and freedom of choice, like we maybe think that it does. So, just some interesting final questions to consider, and that is all for this reading.